Okay, we're moving on here to Chapter 2 in the textbook. We're going to review a number of things. Learning objectives covered in this particular chapter start with a more detailed discussion of the Fair Labor Standards Act. We're going to learn how to deal with the definition of hours worked. We're going to briefly describe the types of records used to collect payroll data. That's a very simple learning objective there. We're going to learn how to calculate regular and overtime pay. This is a major computational issue, and this is starting to get into the meat of the course, the things that you have to learn how to do, how to repeat. And then we're going to get into some more distinctive compensation plans that have a little bit more complexity in them in the way they determine total compensation. So keeping this in mind, let's go review that Fair Labor Standards Act, not to overly repeat the detail in it, but it is such a pivotal and important act that has to do with payroll that we need to become more familiar with it and to understand why we're doing the things that we're doing when we get to the computations that we make. So as a reminder, as we talked about from Chapter 1, this was the pivotal act done in 1938, signed by Franklin Roosevelt, and it established record-keeping requirements, minimum wage, overtime pay requirements, child labor restrictions, all of these things embodied in that Fair Labor Standards Act that were the foundation of how we complete payroll today. Now that act has been amended and improved and changed as to the original intent of the act, but it was a pivotal and major change when it was signed back in 1938. So what was that act all about as a reminder? Well, it covered firms engaged in interstate commerce, those laws, regulations that decide who it falls under the Fair Labor Standards Act have expanded, got more detailed, and essentially these two tests are used, the enterprise test, the individual employee test. Basically, if any trace of work in that enterprise is done involved in or attached to or related to interstate commerce, you fall under that act. So very few firms avoid that now. There is a minimum annual sales level that also is applied, but in general, we're not going to have to make those distinctions in this course. We're going to assume most, if not all, of the firms that we look at fall under the Fair Labor Standards Act. Note here, many family businesses are exempt. They're some of the few that simply can avoid the requirements of the Fair Labor Standards Act because it is a family business. We talked about some of those issues having to do with child labor in Chapter 1. Okay, the first thing we need to do, and this is an outshoot of the Fair Labor Standards Act, is what is an employee and an employer? This definition is given here. Employer is an individual who acts directly or indirectly in the interest of the employer in a relationship to an employee. So that's an important common sense view of what an employer would be. If an individual is an employee, if he or she performs services in a covered employment. So it establishes what they call a common law relationship between the employer and the employee. There is an IRS test based on such things as behavioral control. Does the employer control what the employee does at the times they're in the employment area? Do they have financial control? What is the relationship between the parties? Specific rules apply to employees of corporations, domestic employees, partnerships and partners and partnerships. Those are more specific than these rules here. These are specified for other forms of business organization, corporations, domestic employees, partners and partnerships. So the law has that complexity to deal with the other forms of organizations. We're not going to have to answer too many of these questions, but it is an enormously important question, and many times firms ask the IRS to tell them, here's the relationship we have between these two parties. Is this party an employee, or are they an independent contractor? And that would have huge implications as to how they're treated in that relationship. So we'll just mention here that there is a simple ABC test that the IRS has that you can apply to and send them the information and ask them to make a ruling on it. And that shortened test deals with these issues. An independent contractor is someone who then would not be an employee, but is free in the direction and control in the performance of the work. So if you tell this party that they have to be somewhere at a certain time and they have to do these kinds of things, then it's very likely they fail that test, that A test of being an independent contractor. They're not free with the control of the performance of the work or the direction when they're told when and how to get it done. You're an independent contractor if you perform services outside the usual course of business of the company that has hired the contractor. So the services you perform wouldn't be exclusive to the type of services needed by the company, but they're outside as a professional service provider. You provide services that are outside of that scope, which would lend credence to the notion that you might be an independent contractor. And you're an independent contractor if you're customarily engaged in an independent occupation. So all of these can be very subjective. They're important issues depending on exactly what the agreement is between the potential employer and the employee. You submit, or you can submit, and you probably should submit in difficult cases, information to the IRS. You fill out a specific form and ask them, is this under the law an employer-employee relationship, or is it an independent contractor relationship? And I believe the book mentions this, that well over 90% of those applications result in the IRS concluding that this relationship is employer-employee and not independent contractor. So that helps us understand that it is important to know whether a relationship is that of an independent contractor or an employee-employer. If you get it wrong and you proceed down the road thinking it's an independent contractor, a lot of payroll can go by, or a lot of compensation can go by that should have been treated as payroll, and you wind up with that liability and that problem if you have improperly defined a particular relationship as independent contractor rather than employee. So we need to keep that in mind. We're not going to be asked to make those kinds of decisions here, but you need to be aware that in the real world it is a decision that has to be made quite often and very carefully. Fair Labor Standards Act, in dealing with domestics, which includes nannies, gardeners, chauffeurs, and etc. These are issues that come up under the Fair Labor Standards Act. These employees must earn the minimum wage and overtime if they meet this work 8 hours per week or more, or earn at least $1,000 in a calendar year. So that's pretty restrictive, and that indicates that the wage that's paid to these people, as they fall under as a special type of employee, if they meet that pretty low standard, especially for things domestics like nannies, they fall under the Fair Labor Standards Act as to minimum wage, and they must be paid the minimum wage. If they're live-in domestics, because of the difficulty of defining overtime in that situation, they need not be paid overtime. So domestics are a separate item, and this comes up a lot in political races where they discover someone running for office has possibly hired and failed to meet all of the requirements of the Fair Labor Standards Act or one of the immigration acts in employing and using domestics in their home or for their family. It can't be ignored. It's an important issue, even though you don't think of yourself as an employer normally that would fall under the act. In fact, you very quickly and easily can. What is minimum wage? Well, it includes all rates of pay, not limited to regular pay, commissions also, non-discretionary bonuses and severance pay, on-call or differential pay. So it's included in all those things. It isn't simply the rate per hour in that wage environment is also these other forms of pay or ways that we can earn and get pay. The non-discretionary bonus is one where the employer, it's committed to the employee, and the employee gets it no matter what happens. It doesn't, you don't come to the end of the year and say, well, do you deserve the bonus, or were you profitable enough to have the bonus? In other words, the employer has some discretion in those cases. That is outside of the minimum wage issue. They're not included as showing that you met the minimum wage if it's a discretionary bonus. But if it's not discretionary, it can be included in what is considered the pay to meet that Fair Labor Standards minimum wage. And this is something I just mentioned. Discretionary bonuses not included in the regular rate of pay, not agreed on beforehand. Other types of compensation not included in the regular rate of pay. Gifts. You can't give employees gifts and then argue that helped them meet the minimum wage that you were supposed to meet under Fair Labor Standards. These other items here, tool and uniform allowance, vacation, holiday pay, again, those are not included in the regular rate of pay when you determine whether or not you are paying minimum wage. Minimum wage versus living wage. Currently, minimum wage federally is $9.25 an hour. In the state of Washington, I believe the rate now is $9.09 or 10 cents, somewhere around there, higher than the federal rate. So, of course, if you're an employer in the state of Washington, you must meet the higher minimum wage. There is this movement and this argument that it's inadequate, and in fact, this very summer we're seeing protests and organizational demonstrations by those folks working at minimum wage in some of the fast food establishments chains nationally, where they're arguing that the minimum wage they're being paid isn't adequate, it's not a living wage, and they're demanding a higher wage. This debate has gone on, it's going to continue to go on most likely. There was a proposal in the Obama administration to raise the minimum wage rather abruptly in steps to $9.50. This hasn't come through as the law. However, it is, that debate is going to continue to come up again and again and again. Is the minimum wage a living wage? No, it isn't a living wage in most cases. In most cases it's a wage that is supplemental to a family unit that is trying to meet a living budget. There are certain exceptions to minimum wages, and we've mentioned some of those. Those details are available to us as we proceed. But this living wage issue that we're referring to, that's a term and a phrase used for this movement in local law in city by city, and there are many cities that have a living wage requirement where they insist that if you're an employer in that city under the benefits that city provides, that you will meet a higher standard as to the wage that you pay workers, and that wage brings them closer to being able to deal with the cost of living with that particular level of income. So it's telling us here that the research done by the authors of this textbook are telling us that over 100 cities currently have local laws requiring employers that do business with the government. That's kind of the hook. If you're here doing business with us, you've got to pay this living wage. There are locations that are moving to get a blanket living wage law passed for all business operations within the city. Okay, so don't expect this debate to end quickly. We're going to see more of this. It's a major issue that has to be decided on in our government, in our process, in our economy. What's the best for labor? What is the best for the economy? Is it higher minimum wages, or is it leave that issue between the employer and the employee in the interest of job creation? Those two ideas are going to tug at each other and manifest themselves in arguments and demonstrations for some time. I mentioned earlier now the bullet point back up here where there are exemptions to minimum wages. Here, just for purposes of kind of discuss it, this is one of the schedules in the textbook. This is listing many of the exemptions for the Fair Labor Standards Act. And again, we're not here to memorize these or have to know these or to repeat these. If we need to look them up, we can. It's readily available to us. It's just to continue to give you this scope of understanding that it is complex and different situations require a careful look at the law and the detail of the law to see what the standards are. But minimum wage exemptions, all these X's here, teachers, executive administrative personnel in school, we're exempt from paying them the minimum wage. Agricultural workers, members of the immediate family, they're exempt. Recreational establishments that have seasonal peaks are exempt under the law as demonstrated here. Newspaper employees that are published weekly, semi-weekly, daily, if they have low circulations, 4,000 copies or less, they're exempt. And you sort of wonder how these things get into the law. And as I mentioned last in the Chapter 1 discussion, you have to expect a lot of this is influenced at the time the law was drafted and created by advocacy groups, industry groups, lobbyists, whatever term you want to use. They get involved in these things and they propose language and they propose rules. They give arguments why those rules are there, and legislators sometimes are sold on those ideas and they put those in as a condition of their vote. We also see here some exemptions that are possible for the equal pay provision. Now, the equal pay provision in the Fair Labor Standards Act of 1938 was not as involved as it became, because the issue really, it became clear that between men and women, even in spite of this equal pay provision in the 1938 law, employers were still violating the spirit of it in that they were demonstrating discrimination in the level of pay they paid men versus women. That debate continues. It's not, that argument is still present, that it's still unfair in the workplace based on the compensation women receive. But an amendment to that law was passed in 1963 and signed by President Kennedy that was very specific: equal pay, equal work, and it targeted the issue of discrimination based on sex, paying women less than men. But in spite of that, there are these issues. These agricultural workers, members of the same family, the same seasonal amusement park employees, babysitters, low newspaper circulation employees, they're all exempt from the equal pay provision. Some of it for probably good reason, some of it you wonder how it gets in there. And the overtime exemption, the exemptions are much more liberal. All of these listed here, including taxi cab drivers, don't have to be paid overtime. And I would assume that's because of the nature of the work they feel. They expect to work longer hours, and that's just the nature of the business, and so it isn't particularly an overtime issue. At any rate, this isn't here to memorize. This is here to remind us that it is complicated, and you do need to look at these matrices sometimes to make the decisions and to consult on a particular issue in the real world. In this class, we're not going to be doing a whole lot of this. We're just aware of it. Okay, here's one of the issues that's going to become important to you, because you're going to be doing problems with this problem in it, tips. And tips are a form of compensation, and they have to fit into the minimum wage law, and that the law and the regulation of that law have specifics about tips, and it becomes involved and somewhat complex, and so we have to get used to this, and this is an issue we have to deal with in the course. You're going to have these types of problems, tipped employees. So we would define a tipped employee was one who regularly averages more than $30 a month in tips. Now that's a regulation, and that's going to change over time as inflation attacks that. That has to be, kept up to date by the regulators of these particular rules. So right now, the minimum wage that you pay a person who is tipped is $2.13 an hour. That doesn't mean they fall under a lower minimum wage. It just means that you establish that minimum that they are paid, and then it is tested after the fact to see if they really did earn the minimum wage. So if the minimum wage is $7.25, you subtract from that the established minimum tipped wage, and what the law is saying is that you have to make up that $5.12 difference from tips. The tip credit is that much, and if the tips don't bring you up to that, you have to make it up. You have to bring it up to the minimum wage. So you're allowed to start out with this as the base because your employee is tipped, but the tips have to come through. And so one of the more complicated problems, and we'll do this and show you this issue when it comes up, but when you have overtime pay calculation and the tip credit of currently at $5.12, sometimes it gets a little bit complex. We'll deal with that when it comes up. Okay, so here's some examples of tips received for a 40-hour week. Here's the tips reported, $43, and this is telling us that since the minimum weekly gross must be $290 at minimum wage, 40 hours times $7.25, this employee reported this much in tips, assuming that they had this minimum as their base. We just ask a question. Okay, 40 hours times the 213, which gets us to $85.20, and then add their tips to it. Is that number greater than the minimum that we need to be paying them? The answer is no. And so we have to pay them an additional amount. So the additional amount they must be paid is an amount to get them up to the $290. So that's an important example. And in this second example, number 2 here, they have this huge $1,189 in tips, and in this case, most certainly it exceeds the minimum wage of $290. So the employer doesn't have to provide any additional compensation. But importantly, look, it doesn't mean the employer doesn't have to pay this $2.13 an hour. That's still required, even though the tips far exceeded the $290 minimum gross. The employer still must pay this $85.20 because the tip credit is only $5.12 an hour. The tip credit isn't $7.25 an hour. So that's important nuance. And when we get to these problems, we'll point that out and make sure that you understand that and get through those. Okay, this is a reminder down here then that this tip credit percentage made at a state level may be different than federal law. States are involved in this issue too in their minimum wage calculations and procedures, so you have to keep it in mind that you may have the federal process figured out, but you better be sure that it's consistent or not superseded by the state's rules. So that helps us understand that TIPS employees are dealt with under the minimum wage law in a specific way. The examples are pretty demonstrative as to how to approach that. So we'll come up into these problems, and they're going to be in Cengage Now, scheduled as problems. You'll run into them in this Chapter 2 homework that we're doing. Let's move on to another major idea that was put into the law in that Fair Labor Standards Act, and that was overtime. And that meant that if you work more than 40 hours in any week, you're to be paid time and a half for the time over 40 hours that you work. So we have to have some idea of what is the work week, and here we're given some of the detail in the law and the regulation. Must be 7 consecutive 24-hour periods. For example, here's one starts on Saturday, ends on Friday. Some states require daily overtime if it's over 8 hours. If the state plan is more generous to the employee than the Federal Fair Labor Standards Act, then the state law is to be followed. And what they mean here is that more generous is that maybe you would work 9 hours for 4 days for a firm, 36 hours in total, and under the federal law there would be no overtime. But maybe under the state law, if that's the law in the state you're in, that extra hour, that 9th hour on those 4 days constituted overtime because they felt overtime was reasonably defined as those hours over 8 rather than the hour in a day rather than the hours over 40 in a week. The rate that was set when this law was first established is 1.5 times regular pay. Employers, this has been tested and argued and talked about, it is legal to require your employee to work overtime. And I think the reason that that's probably been confirmed and is part of the regulation is because of the other part of the law that says, yeah, okay, you can make them work overtime, but you got to pay them time and a half. Okay, exceptions to there's always exceptions to these rules. Okay, here are some of the exceptions detailed. Hospital employees, overtime is for 80 plus hours in 14 days or over 8 hours a day, whichever is greater. And I think it has to do with the nature of employment in a hospital sometimes, where they work very long shifts, especially new interns, just due to the nature of the cycle of seeing patients, reviewing patients, and getting them through critical periods argues for more than an 8-hour shift. And so the law accommodates that by dealing with what constitutes a work week and what constitutes overtime in a hospital setting that's greater than the rest of the industry. Retail or service industry employees that are commissioned earning, they follow special rules. They are exempt from this simple rule. There are other overtime rules that are involved for them. If you have an employee that is being educated and involved in the process of receiving that remedial education, they are, for that activity, exempt from overtime. So these are, again, nuances of the law and definitions of regulations that involve to deal with these issues over time after that original statute was passed. Okay, so overtime provisions are going to come up in Chapter 2 problems. They're a major part of the computation that we have to do, and we have to get used to some special situations that we'll see. The simple ones are easy. The more involved ones, where there are other rules applying and their difficulty in defining what is overtime, we'll encounter those as well. And we'll make sure that we review some of those examples here in these lecture discussions. Okay, another nuance or tweak to this overtime issue has to do, in general, this comes from firemen, EMTs, those that are working in public safety. This is where this sort of came to pass, where instead of paying them compensation for working overtime, and because of the nature of what they do, firefighters' time in the station, those kinds of things, it argues for more than 40 hours in shift, or more than 8 hours in a shift, or whatever it may be. And they have allowed, and they do allow, comp time. In other words, instead of paying you overtime, you get time off paid at regular rates, and it can accumulate and you can build that up. And as a result, for example, some firemen have schedules that are very intense, and they work very long periods of time for, day after day, very, very intensely, but they build up this comp time, where then they get extended periods of time, week or more off, and they use their comp time as the pay during that. And that does fit maybe the demands of the job, where they can get a little bit refreshed and get away from the intensity of the job and possibly the danger of dealing with public safety issues that they deal with, and the emotional drain that can be, and it allows them to recharge a little bit. So that law, that tweak of the law on overtime, comp time, deals with that, and there are specifics like you have to pay that when they leave employment. If it builds up, you can't simply say, well, you're leaving, so all that comp time you build up is wasted. No, they have to be paid for it if it is a termination. So it's generally public safety employees that fall under this comp time rule: EMTs, firemen, policemen, those types of workers. Okay, another issue, and this is the detail of Fair Labor Standards Act that is hugely important we are not going to have to make these determinations in this course, but in the real world they're major, and if you get this wrong and start payrolling someone as an exempt employee, you can have an enormous liability built up in doing it incorrectly. And what it means is some employees are exempt from some or all of fair labor standards in a firm. Okay, so it's not, if the firm falls under the Fair Labor Standards Act, it doesn't mean that all the employees in that firm fall under it. And in general, it's the higher end management, in other words, the white collar group, that very often are salaried. They're not wage earners. They don't punch a clock. They're expected to get something done, and rather than to complete a time slot like wage earners are. We often call those white collar workers, and many of those are defined as exempt employees. You don't have to meet the requirements of the Fair Labor Standards Act in their employ. So this is a list of folks who are outlined, and this is referring to the figure in the textbook, that where the exemptions are there for them from the Fair Labor Standards Act. Executives, administrators, professionals, highly compensated employees, business owners, creative and computer professionals, outside salespeople. It's not a simple determination to find out if you're exempt or non-exempt, but you need to do it, and you need to ask for a ruling if it's necessary in the situation that you're in. This is telling us that there is a base salary that's a minimum that must be there for you to be an exempt employee, and there's a list of requirements or duties that you must meet. It's listed in the textbook in Figure 2-2. So those resources are there for us to make the determination. Be aware of it as a student in your first study of payroll. Just be aware of that issue, and don't be concerned that we are going to make many of these determinations, because they're very subjective, and a lot of data has to be put together to even set up a situation to determine if someone is exempt or non-exempt. But it's a big deal in the real world. And I think these last 2 points here, blue-collar workers are always entitled to overtime pay, which is a Fair Labor Standards Act rule, of course, and that includes the public safety folks we were talking about that get comp time very often. Licensed practical nurses, paramedics, EMTs, firefighters. And this is probably the best note on this slide here for anybody trying to understand payroll and payroll law, is that you can't just take someone off a wage and put them on a salary and then say they're exempt. They're not. They have to meet all the other rules of the employment. And I'm aware in my career of situations where an employee of a firm was on a salary for years, for 20 years. A salary, was in a small, closely held firm, worked in a happy relationship with the employer for all those years salaried, and then after they left the employment, ran into an attorney that, in hearing how that agreement was structured, told them that you were unfairly treated there. You should have received a massive amount of overtime because you were not exempt. And as a result, that employee sued the former employer and won in court and took hundreds of thousands of dollars in compensation from the employer. It was innocent. In my recollection of this particular issue, when it came up in my career, it was a client that was the employer involved in this in the banking industry, and it just pointed out to the fact that, boy, you just do not take these things casually. And in this particular case, the employee went to work at a salary and did some work maintaining part of the employer's business operation, but didn't do it on any regular clock. Came and went and did things as they were needed, and no one paid any attention to the clock. And unfortunately, you can't do it that way. And unfortunately, it did set up this case where they were working many, many times in excess of 40 hours a week, and they were able to establish that after the fact for all those years of employment. And they did some calculations and said, Mr. Employer, you owe that employee for all that overtime that was overlooked. So you can't take this issue of exempt and non-exempt casually. You must pay attention. You must be careful in the job descriptions, the job definitions, and you must ask for a ruling from the IRS if you think it's appropriate, if you don't understand it. And it's best to err on the side of you're not exempt from these Fair Labor Standards. We need to follow those Fair Labor Standards. Okay, so here is, I referred to this in the slide earlier, I referred to this here, these list of requirements, the test of exemption. Here they are. They're up here for us to take a look at and look over these indications that you might be exempt. Again, this is subjective in many of these cases. Like you're a professional, you have knowledge acquired by a prolonged course of instruction. Well, you know, that could be true of a wage earner. That could be true of a skilled craftsman. So these are not easy determinations to make, but there certainly are a pitfall if you make them incorrectly and you're ruled against later on as you go forward. So this information is available in the text and here on PowerPoint for you if you wanted to get into any more detail. Okay, I mentioned the equal pay for equal work, which was a provision of the 1938 Fair Labor Standards Act, but it didn't really address the issue for men and women. Women still didn't technically fall under that specific equal pay for equal work, and the evidence was being shown for some time that they're being unfairly treated collectively by employers. And so in 1963, under President Kennedy, the Equal Pay Act, which amended the Fair Labor Standards Act to tighten it up for discrimination between men and women, and it's not allowed anymore. There's no wage differentials due to sex. Here is President Kennedy with all these ladies, and there's LBJ right behind him, signing this act. I'm looking for Jackie Kennedy here. I don't see her in that picture, but this was certainly a pivotal piece of legislation for women's rights, and JFK is happily signing that in that picture that we see. The debate goes on. The argument is that this act is still not removing the differential that is observed in statistics, and there's lots of arguments about whether that's inappropriate or appropriate. So we're still going to see this as a political issue in the future. Now, we talked about child labor issues, as for example, in the Chapter 1 discussion. There's no need to get into any example details because we did a pretty lengthy detail before. We don't want to get into it, but it was part of the 1938 Act. It's an issue that we need to watch and be careful of. And again, we're not going to be given to any problems where we're trying to decide what rules or restrictions an employee in a payroll situation falls under because they are children or youths in the 14, 15, 16 age bracket. We're not going to get into that, but we just need to know it. If you're going to be involved in payroll, you have to understand that when it comes to employing children and youths under the age of 18, very detailed restrictions, and we need to maintain our understanding and consult when necessary on those issues. It says here, this little reminder, serious fines. You know, they don't take these violations on child labor restrictions lightly. Okay, so then the last thing we want to talk about, what doesn't the Fair Labor Standards Act cover? These are important things to remind ourselves. It doesn't require employees to grant sick leave. Now, that doesn't mean that you wouldn't have that requirement. And as I pointed out in the Chapter 1 discussion, for example, the city of Seattle all of a sudden popped up in 2011 and says, yes, you will. You'll provide sick leave and paid sick leave for employees that work here. So just because it's not covered federally doesn't mean it wouldn't be covered. Have to find that out. Same with vacation time, same with holidays off. These are not issues that are automatically in the law in this foundational law at the federal level. Doesn't mean you wouldn't run into them in state or local law. but it's just pointing out that it isn't as all-encompassing as some people might expect it to be at times. So this is a list: paid for weekend holiday work. Those issues may be superseded by local and state law, even though they're not covered in the Fair Labor Standards Act. Okay, that's it for this detailed and lengthy discussion. From this point on now, we're going to be getting into computations, and this is the meat and potatoes of this chapter 2, is these computations that we have to do. And we're not going to be having as many of these discussions about the history and the legislation and the bullet points of the law that we get into. A little bit of that when we hit income tax withholding and Social Security and unemployment. And we're going to go back and talk a little bit more about these things, just to make sure that we have a foundational understanding of why we're doing the computations that we are. But for the most part now, we're going to be immersing ourselves in calculating overtime, calculate hours worked, having a piecework situation that we have to convert to minimum wage, or having a tipped situation convert to minimum wage. Those are all things that we're going to tackle here in Chapter 2 homework.